So a little bit about myself and NB Property Law. So as I mentioned, I am the director here at NB Property Law. So we do specialise in commercial, estate planning and residential property matters. We are part of the No Borders Law Group. So No Borders Law Group also has an employment law division and a migration law division, and have been around for 27 years now. So we bring broad experience from private practice and local government. I've advised on many complex leasing matters, acquisitions of land, and also property development projects. I've got experience in estate planning, including drafting complex wills and power of attorney documents, and also dealing with, applying for probate, administration, and wills that are being contested. My passion, though, lies in, delivering practical, commercially focused advice that supports my clients' business growth and also ensures smooth transactions for them. So our agenda for today, so we're going to do a bit of an overview of the new anti-money laundering laws that are coming into place and the reforms surrounding them, and talk about their commencing date later into 2026 and what impact we're going to see that they're going to have on property transactions. So we'll talk a little bit about how buyers and sellers are going to be affected when it comes to things like their enhanced verification of identity and where the source of their funds have come from. We'll go through some of the key policies and documents that are going to be required both before and during a property transaction. We're going to speak a little bit about as well the AUSTRAC compliance expectations, what some of the common risk areas are, and how you can avoid those delays. So to start off more broadly, what actually is the anti-money laundering and counter-terrorism financing reform? So in 2006, the federal government passed the Anti-Money Laundering and Counter-Terrorism Financing Act to combat money laundering and the financing of terrorism. This obviously was post the September 11 attacks, and certain extra precautions were taken as a result of this. So fast forward now to 2024, almost 22 years later, we've now got a new piece of legislation, or a bill, should I say, which has been introduced to basically bring about some major reforms to this AML or CTF Act. And part of its purpose is to actually protect businesses from being used to launder money, fund terrorism, or proliferation financing. So often, things like casinos and things have had, anti-money laundering laws and things in place. It's now creeping out of there a bit, and they're introducing it to more industries. So this was introduced basically to fulfill our international obligations as well. So, as part of, international regulations and laws, each country has to have their own set of anti-money laundering and counter-terrorism financing reforms. Some of these, our sister nation, I'd say right next to us, New Zealand, they've already got some of these in play. We're probably behind a little bit in introducing some of these, and they probably weren't up to scratch, but we're essentially, we're getting on to that now. So how is it going to be achieved then? So a designated service provider must have policies and procedures in place to document both the anti-money laundering, terrorism financing, or proliferation financing risk assessment, and have these AML or CTF policies in place. So designated service providers under the legislation includes real estate agent professionals, lawyers, so ourselves as law firms, conveyancers. So in New South Wales, you don't necessarily have to be a law firm, you can just be a conveyancer. While in Queensland, to be a conveyancer, you must be acting under a law firm banner. Accountants, and also trust and company service providers. So in essence, basically, if you handle clients' funds, or you're undertaking large transactions, or you have a high risk of financial activity, then these laws and these new laws are going to impact you and your business. So what do the terms mean then? So what is a designated service? So designated service in the Anti-Money Laundering and Counter-Terrorism Financing Act, and we're going to talk about, money laundering. So this is the process of actually dealing in and disguising or concealing the origin of illicit funds to make it appear that the funds come from a legitimate source. So, this is basically, fraudulent, essentially, that the money is come from somewhere, they're trying to wash it away and use it for something else, so that it is never, comes to the government's knowledge, essentially, that the funds are essentially illegal. So, for example, if someone was to rob a bank per se, and they're using that money to then purchase a property. The government, they're providing, some examples and things like that. So their website does have a few resources and different examples that they talk about as well on there. Now, terrorism financing. So this is the means and methods that terrorist organisations use to finance activities that pose a threat to national and international security. So the money that enables terrorist organisations to carry out terrorist activities can come from both legitimate and financial, and criminal sources. So, you've got terrorists that have everyday jobs. They could be funneling that money into this terrorist organisation, but then they could also be criminal sources for that funds as well. So, the example before, they could be robbing a bank to also help fund that terrorist organisation that they're got established in, potentially our country. So proliferation financing. So what does this mean? So this occurs when a person makes available an asset which provides a financial service or conducts a financial transaction that is intended to, in whole or in part, facilitate the proliferation of weapons of mass destruction, regardless of whether the activity occurs or is attempted. So it doesn't matter that, for example, this terrorist organization may have a planned terrorist attack, and they've used this money to purchase these, illegal weapons of mass destruction. It doesn't matter that that never took place and they never actually used the illegal funds for that purpose. The fact that that was the intention is enough. Retirement villages, though, they may be exempt if the agreement is a license agreement as well, as opposed to an actual property purchase. So that's probably something to note. Now, what are designated services? So while that previous slide I've gone through and given you, the clear definition of what a designated service is, these are some of the examples of a designated service. Like I said, it's not going to include retirement villages where it's under a license agreement, as opposed to actually purchasing outright that potential property. But it will include when you are assisting or completing a transaction to either sell, buy, or transfer real estate. It will also include if you're receiving, holding, controlling, or managing a person's property to complete a transaction, or help in planning a transaction. I think these are, quite self-explanatory, but if anyone does need further information or examples, then feel free to put a chat in the chat box and I'll be able to answer them. But otherwise, I will open it up to questions at the end of this session. Another designated service is actually selling or transferring shelf companies. And last example that we've got here is providing a registered office or principal place of business. So that obviously, a lot of accountants provide that service where they've got, their clients, principal place of residence is that accounting firm. So, that means, they're going to be affected quite dramatically in that regard. So key elements then. So what is the risk assessment and what do you need to consider? So what sort of risk does your business face? So is it more likely that your service would be used to launder money, fund terrorism, or actually fund financial nuclear weapons? So who is your customer base? Is it more likely to be individuals, complex legal structures through a third party, or are they from a high-risk country? So what is a high-risk country then? So these are determined by the government and based on a number of factors. So you're deemed to be a high-risk or non-cooperative jurisdiction by the Financial Action Task Force, which is an Australian task force, and they're prescribed foreign countries. So they're subject to sanctions, they're known tax havens, they're known to provide support to terrorist organisation, but AUSTRAC does also have a list. So at the moment, currently we've got Iran and North Korea, but there are other examples on the AUSTRAC website if you're unsure of what would be considered a high-risk country. In terms of identifying the high-risk transaction as well across the actual network. So, for example, the example that the government gives is savings banks provided a financial service for products to a large portfolio of customers. So savings banks has a transaction monitoring program that monitors all customers to flag various behaviours. So, they've got a bank that's operating, they're then, they're could be their customer, their call center, or their front office counter, and basically they're responsible for flagging customer behaviours that are linked to risk that identified with Savings Bank recently updated their actual laws for their risk assessment. So we see this already, when we're calling our bank, we're asked a series of questions, to make sure that, it's not just obviously anti-terrorism laws, but it's also to deal with, fraud. Obviously, fraud's a big thing at the moment at banks, so they've got a lot of different checks and balances in place. So, the banks need to be ensure and be certain that a criminal network is not using their bank to essentially facilitate the activities. So, in this situation, unbeknown to Savings Bank, a network of 12 criminals come and open a new account with them. And so these criminals are essentially planning to receive a transfer of funds into their new account and wait several days and then transfer the funds to multiple overseas accounts. That could be for various different things, whether they're purchasing weapons or to fund those terrorist organizations in multiple different countries. So Savings Bank's risk assessment in this situation is to identify the overseas jurisdiction as high risk. They've got, as a result, they've created alerts in their transaction monitoring program to flag individual customers transferring greater than $5,000 in a single transaction or greater than $20,000 over a 28-day period to that jurisdiction. So, that's stopping them, just doing, say, just under the threshold of, $20,000, but multiple of them. So in an attempt to avoid detection, so the criminals move no more than a total of $15,000 per month in small batches to the high-risk jurisdictions, so these countries overseas. So after several weeks, 2 members of the criminal network became more brazen and each transfer the full amount of $15,000 in one transaction. So automatically, an alert now has been triggered with this Savings Bank's transaction monitoring program, and this triggers the alert on their actual account as well. And following further review, the 2 SMRs actually has to then be provided to AUSTRAC. So if we do come up with risks and we've got someone that we need to flag, AUSTRAC then need to immediately know. So the transaction monitoring program, though, in this situation, it would be considered as failed because it hasn't identified the patterns across the full criminal and activities network. So the law enforcement had an interest in this particular network, and after receiving the 2 SMRs, serves a notice on Savings Banks for further information. And on examining the additional customers, Savings Banks were able to actually see the full activity of the network. And as a result, this Savings Banks provided a series of SMRs to AUSTRAC. So, there are ramifications if we don't have the correct checks and balances in place. AUSTRAC are going to be coming after, potentially our businesses to question us further, and penalties may be payable if we're unable to provide the information needed. So in order to address the limitations then of this example of Savings Bank's transaction monitoring program, obviously it was limited. The risk posed by the individual customers transferring funds to the high risk jurisdictions were not adequately identifying multiple customers sending funds to the actual same beneficiary. So it wasn't actually just one of their customers sending money, overseas constantly. They had a network of 12 criminals, but they were all sending similar payments over to this overseas network, which was the bank's responsibility under these new laws to pick up. So it was also unable to identify the patterns across the network, which could have been revealed, for example, if the transaction monitoring program had been set up appropriately to deal with these risks that the jurisdiction presented. So as a result, Savings Bank reviewed the capabilities of their transaction monitoring program and we're obviously forced to make the changes to ensure it's identifying patterns of behaviour, not just at the individual level. So obviously banks, they've got a higher risk again than what we're going to have as, the accountants and lawyers, because they're dealing with transferring that money to, potentially end users who, are overseas, who are, operating. We know they've got, multiple different accounts set up and things like that. Now, like I said, we need to know what the risks are though. So, how is our service delivered? So, are we maybe similar to the banks? Potentially, are you giving out money to multiple different people? Maybe you've been instructed to do a property sale, and all of a sudden you're the one transferring 12 payments to an overseas bank account that you don't know the owner of. So, do you conduct most of the services in person, online, or is it done through a third party as well? With property settlements, in Queensland, we're now mandated to use PEXA, so all the transfers would go through there. What liability then does that place on PEXA as well as the actual payer of that money? And they've got their own checks and balances in place as well to avoid things like cybersecurity. And I'm sure as all this legislation evolves, there'll be more ticks and balances in place as well for probably making sure that the account owners undertake their own VOI as well as not just the buyer and seller, which is what it currently is. What jurisdictions are you actually operating your business from? So are you mostly dealing with Australian citizens or customers from overseas? So if there are overseas, are they from those high-risk countries that we went through before, which is currently Iran and North Korea? If you're dealing, as an accountant or as a real estate agent, you are from time to time going to have foreign buyers. So this does add a layer of complexity, and needing to check that what their status is in terms of country that they're from, and that can be done with your VOI because you'll ask for a passport. You'll probably require their documents to show what their immigration status is in Australia as well. What sort of services and products are you actually providing? So are most of the customers cash buyers? Are they property flippers who buy and sell quickly? Those types of buyers, they're more risky under this legislation because they're the ones that are coming in to launder the money. So yeah, while they might put in money into a property really quickly to flip it, they're still essentially laundering the money because they might have put $3 million into a new build, and all of a sudden in 12 months later, since that project's complete, they're then washing their hands clean of that dirty money essentially and going on to buy something else. All right, so what are the key elements then? So, we understand what the risks are. Now we've got to develop these AML or CTF policies and procedures. So we've got to have a program that must be set up that documents in writing how the reporting entity, which is your business, will manage and mitigate the risks identified in the risk assessment, and how you're actually going to ensure that your ongoing obligations are met. So a senior person will need to be nominated, and that person is responsible for overseeing the policies and procedures and ensuring they're up to date and compliant. So like any law, they're going to change from time to time. We can't just set and forget. We can't just put in a policy today and expect that it's going to be valid in 5 years' time. We really should be reviewing all policies and procedures we have in any business on a yearly basis. And we're going to have one person that's a senior person in that business responsible for it. If there is only one senior member of reporting entity, it can be the same person that's doing this and also acting as the compliance officer. So the compliance officer is going to need to be nominated as well, and this person will be responsible for overseeing and ensuring that the ongoing implementation of the policies and procedures have taken place. AUSTRAC has indicated, though, that a program or assistance will be provided to small businesses. So obviously, this could come at a big cost to small businesses to implement such a program and policies and procedures. So AUSTRAC has indicated that they are going to provide some assistance to our small businesses. What level and how that's going to look, we don't know at this point in time. We were supposed to get some more information at the end of last year, but we're still waiting, and it seems to be being drip fed to us in stages. So small business, like I said, unlikely they're going to have 2 people to even operate the both the nomination of overseeing the policies and procedures and also being the one that is responsible for the compliance of it. We can have that same person, and as time goes on, AUSTRAC has outlined they're going to provide some more information as a free resource to small business owners. So then what should your policy and procedure actually contain? So how do you go about doing an advanced customer due diligence if they are a high-risk customer is what we need to be including in this policy. We need to stipulate in it how we're going to verify and check the beneficial owners of a complex legal entity. So that might involve obviously getting copies of trust documents, obviously getting verification of identity for the individuals if there's individuals nominated under that trust. And then obviously policy and procedure, one of the big things is what actually are the red flags? When do we, like that example I gave before, at what point should the bank's monitoring program picked up that there was a red flag to then, pass the information on to AUSTRAC? What extra checks are required if it is a cash or a non-finance transaction, because they're one of the more riskier transactions, as I mentioned earlier. So an agent should also be checking for house flipping, as I mentioned before, and also under and overvaluation. So, why have they undervalued the house, or why have they potentially overvalued it? Maybe they're selling it to a related party, telling them that it's worth $6 million when it's only worth $3 million. All of a sudden, they've, wiped clean $3 million worth of money through your business. AUSTRAC has also said that you should be screening and monitoring customers that are involved in military arms and ammunitions. So continuing on with the key elements then, so employee due diligence. So we're a business, we've often then obviously got employees and contractors. And if we do, if an employee or contractor is going to be the one conducting any of the AML or CTF functions, we need to make sure then that we're actually doing checks on our own employees and contractors to ensure that they are a fit and proper person. So they must also be provided with adequate resources and authorities to perform their tasks. We need to be giving them the training that's needed by AUSTRAC to carry out their obligations, but we also, as a business owner, are responsible for ensuring that they're, a sound and proper person and that they've gone through the correct checks and ticks and balances. So, whether that's we're doing, for all employees for these types of businesses, things like the police checks and, is that enough? Is that the extent that the government's expecting? We'll get more information on that, but, as a minimum, we would think that that's something that's going to be needed. AML or CTF training then. So, we've got these new employees, they seem sound, we're okay with employing them, they meet the, the police check and all the other reference and background checks. Now we've got to make sure that we're providing them with ongoing and regular training to provide them with the knowledge they need to be able to perform their functions under the AML or CTF legislation. We also need to have an independent review. So although we've got a compliance officer and someone put in place to oversee these policies and procedures, we also then need to take it one step further and have a review of these policies and procedures done at least every 3 years by an independent person. Again, we'll get more information as to, who this independent person could be, but, we would assume that that is just someone that's appointed to audit, like we would most documents, whether that is, a law firm or whether AUSTRAC decides that they're going to set up a body to facilitate this. Customer due diligence then. So you need to know your customer information. So if we do have an individual acting for, we need to know what their full name is and any other names that they may have been known by. So, have they, a lot of the times we see with foreign buyers in particular from overseas, their passport, it doesn't actually necessarily match even their driver's license. You would think they're two pieces of government issued identification they should be matching. Not always the case. Sometimes I think with driver's license in Queensland, it can only actually have so many characters, and sometimes some of these foreign buyers we see have multiple names and the order of them as well. Like, we already have it, causing, chaos and stuff with banks and transfer documents where, it's been put in the wrong order because, our system, how we see names in Australia is different, for example, to overseas countries. We also need to know what their residential address is, and obviously we need to verify these things. So it's not just okay for someone to say, this is my full name, this is my address, date of birth, etc. We need to go through full verification of identity for them. What is their country of citizenship and their residence? Like I said, if they are then buying in Australia, we need to understand that they've got the right to do that, and checking, what their visas and things like that say. And obviously the main one is where the source of the funds are coming from. So, all of a sudden they've come to Australia, they're purchasing a $15 million property, they've told you they've got cash. it's up to us now to question that. Where's that come from? You know, is it clean money? Is it not? So if it is high risk, we also need to find out their occupation. So, you know, they've told you, oh yeah, I just earned $15 million in the last, you know, 3 years. You know, you've got a 20-year-old purchasing this, you know, $50 million business or property. We need to understand then, you know, how they've done this, you know, in their occupation. What is their occupation and where these supposed funds have come from. So the source of funds, this can be established by obviously asking for records of their bank accounts. If they've told you, no, it's not from an occupation, I've got a loan from, you know, uncle, then we need to see the actual loan agreement. Or, you know, if uncle's given them a gift, we need to see a deed of gift, or, you know, have one drafted up before we accept this service. So continuing on with customer due diligence, if it is a company, as opposed to an individual, we've got obviously separate set of verification we need to go through. So what is the full name of the company and the ACN? What's the date the company was registered? What is the full address of the registered office and the principal place of business? The name of each director, the name of the secretary. What is the nature of the business activities conducted by the company? So basically, until this point, you know, all of the above information we can obviously extract from a company search. We still want the actual client to tell us if there's information to verify that as well. And sometimes, you know, the company information is not always updated if they haven't, you know, got around to updating the principal place of residence or something like that, or removal of director or something that's just happened. Obviously, the nature of the business activities, though, that's going to be something that the actual client needs to tell us, you know, what is their company, what are they doing? And again, same as individuals, source funds, where have they come from, you know, are they legitimate? Okay, different set again of requirements for a trust. So, you know, what we need to know for a trust, what is the full name of the trust? What is the type of trust? You know, is it a testamentary trust? Is it a discretionary trust, a family trust? You know, what type of trust are we dealing with? Are there any business names associated with the trust? You know, do we have a corporate trustee or something like that? What is the principal place of business for the operations? And then we need evidence of the customer's existence. So, you know, how did this trust come about? You know, if there is individuals' names, you know, who are they? Where are they from? You know, we need to verify them as well. You know, we need the full names of the beneficiaries if there are beneficiaries listed in the trust. And then we will also need to basically have completed is the actual trustee's details. So basically, a very simplified way of doing due diligence is if the designated service has been assessed as low risk, so a real estate agent can do a simplified due diligence. The know your customer essentially must be completed, but a service can be provided to a buyer while this is actually still being done. So what is a simplified due diligence then? So essentially this means that the know your customer must be completed, which can simply just be a checklist that each of your, you know, real estate agents or other accountants or other law firm practitioners go through. And if there is no reasonable grounds to doubt the information is valid, no further steps need to be taken. That's the extent of our obligation then to AUSTRAC. Now, if it is low risk, it means that there is an apparent economic or legal reason essentially for the service. So it is not complex or a large transaction, and it does not involve an unusual pattern of transactions, unlike that bank example I went through before where they were constantly transferring money overseas. An agent will have 15 days, so there's a real estate agent, 15 days or of settlement, whichever is earlier, to complete the due diligence. So it appears that real estate agents may be able to make an arrangement with their solicitors to use their assessment, but the rules are not actually clear on how this will be done. So like I said, we're being drip fed information, and we will get more information on how this will actually operate when the time comes for it to commence. So can we outsource this process, obviously, which is what most people do with a lot of, you know, tedious tasks or things they don't know about. So you can certainly outsource the functions to third parties, but you can't outsource your legal responsibility. So this means that the reporting entity, which is our, you know, our law firm, your real estate business, your accounting firm, are still the responsible person if the third party does not comply with the rules. It's the same as, outsourcing, you as a business owner, putting that onus on your employees and contractors. It doesn't matter. You are the director, major shareholder maybe. It is your responsibility to make sure that they're doing the right process, and, anyone that you've contracted out to third party is complying with the laws and regulations. Outsourcing and the risk then. So, you've decided, well, hey, I'm happy to outsource. It's going to make my life a lot easier. I understand that I've still legally got to be compliant, but I'm happy that the outsourcing company is going to do what they need to do. So you can conduct a thorough due diligence to ensure that the service provider actually will be doing the right job. Obviously you want to do reference checks on them, see what their experience is with dealing with this type of work. You need to make sure that they're tailoring the service to your identified risk. You don't want to be using an outsourcing company that's only ever acted for real estate agents when all of a sudden you're a law firm and you've got slightly different requirements. So you need to have the relevant expertise and resources to conduct those checks. Like I said, you'll be doing probably an ASIC search on them, making sure they're a valid company. You'll be wanting to get, not just one reference check, because that could just be a friend or family. You probably want to just have on, what you would do for engaging in any business. Look on their Google. Do they have Google reviews? Contact a few of those people that have given testimonials on their website, things like that. You want to be ensuring that they as well are complying with privacy policies and information sharing restrictions under the AML or CTF Act. You've got those obligations not to be disclosing a client's confidential information. So if you are outsourcing that client's VOI, verification of identity documents, to this outsourced company, that probably needs to be in your terms and conditions to your client, that you are distributing this information to somebody else. So what are the reporting obligations then? So, we've got all these things that we need to comply with. When do we actually have to notify AUSTRAC? So in this situation, it's if we have reasonable grounds to suspect that the transaction or the customer activity may be engaging in money laundering or terrorism funding or criminal activity. So an example I gave at the start with the bank, in that situation, they probably should have been doing it, the moment they realized it was a pattern, which, one transaction, maybe obviously not a pattern, two, potentially not, but by that third transaction, they should have been notifying AUSTRAC. Other reports include threshold transaction reports. So the threshold transaction report is an international value transfer service and also cross-border movement report. So this threshold transaction report can also include if you are accepting instructions to transfer money or property, or if you are making money available to a third party, i.e. release of the deposit to the solicitor. So often as solicitors, we might be the deposit holder and all of a sudden we've sold a property for someone, but for some reason, hopefully it's legitimate, but if it does raise those red flags, we may need to let AUSTRAC know. They're telling us, no, we don't want the proceeds of that deposit, even though we're the seller and we're entitled to it. Can you please deposit that to this overseas company? So AUSTRAC can also require an annual report to be submitted that provides a summary of the AML or CTF compliance. So tipping off, when are we going to tip off AUSTRAC? So if the risk assessment and checks have resulted in a suspicious matter report, a reporting entity such as us, as I said, real estate agents and accountants must ensure that the information is not disclosed to anyone other than an entrusted AUSTRAC person. So that's the only one they need to be notifying at this stage. That's not up to the solicitor to go and, notify the accountant and notify, the real estate agent or any other parties they might be dealing with. Their only obligation at this point in time is to go straight to AUSTRAC. It's an offence to let a customer or their associate know that there is an SMR. We don't want to be the ones tipping off this individual. If it is a fraudulent or suspicious activity, it needs to go straight to AUSTRAC so they can deal with it appropriately. We need to be making an accidental public disclosure. That's an offence. We don't want to be doing that. We don't want to be putting it on our social media or, raising it in our next, big multi-firm meeting. We don't want to be sharing the information to people who may share this information, like a journalist. Sometimes they're quite sneaky. We might get a call from someone. They might not make themselves out as a journalist, but basically is squirming around for information. We don't want to have our receptionist accidentally give that information because we've told her in that multi-firm meeting. There is an ongoing obligation that employees or contractors must still be bound by non-disclosure even after the termination of their employment. So that should be in everyone's employment contracts or contract agreements. If that's not something you have in your employees or contractors agreements, I would recommend getting in contact, with a lawyer. Our employment law team can help with that, or if you've got your own HR professional, whoever it is, to make sure your employee and contractor agreements are actually compliant in that regard as well, and that your employees do have a clause in there that they cannot disclose information, not just while they're employed, but even once they're terminated. Record keeping requirements then. So obviously we've got a lot of obligations. We've got a lot of checks and balances to do. It's not just good enough to do these things and forget about them. We need to actually be keeping these records for a minimum of 7 years. So like I said, if we're completing a checklist before selling a property as a real estate agent, that checklist needs to be stored for 7 years, and it must contain all documentation and information that's been obtained, including client identification and verification records. So we've got very highly sensitive information of clients. It needs to be stored correctly and safely. We don't want that being, a data leak or anything like that, where all that information is gotten out about our clients' personal identification. Details of all their financial transaction that they've done in connection with the designated service we've undertaken also needs to be kept. We need to be keeping the actual risk assessment, the policies, procedures, training manuals, and independent reviews that we've had. Like I said, every 3 years we need to get them done. We also need to keep copies of all the reports that we've submitted to AUSTRAC of any red flags that have been raised. Records can't just be put in a box and kept in an unsecure location that might flood. Again, if that happens, that comes back on us. That was our obligation to do this record keeping requirements, and that's not good enough that, we just tell AUSTRAC, oh, sorry, we got flooded and the documents are gone. So, we would recommend obviously keeping a digital copy as well as a hard copy. Carrying on from other records to be kept, they must be kept electronically or physical, as I've just said. They must be readily available for audit purposes. So again, we don't know how the audits are going to work. It might be somewhat similar to, Queensland Revenue Office, where it's just randomly, they might just pick on several entities each day to come knocking on our door, say, hey, you're part of this record keeping requirements. Where are your records for the last 7 years? We need to see them basically immediately. Records must be held in a way that maintains their security and integrity and complies with privacy regulations. So that's what I said before. We've got a lot of sensitive information we're holding of clients. It doesn't just mean that privacy regulations go out the door. We still have to comply with that as well to avoid those data leaks. If we were previously exempt from the Privacy Act, you will need to ensure that your record keeping practices complies with the broader privacy requirements still. Now, what should we actually be doing then to get ready? Obviously, we don't have all the information, it's not actually all been released as yet. We don't have the, the official start date and things. And, like I said, small businesses are going to be given some resources by the government, but we don't even know what they are yet. So as a first point of call, we think it's important that you're checking that your business will be a provider of these designated services, which I defined at the start. I will provide a copy of these slides as well. Don't expect you to remember everything. So anyone that's been registered for today's webinar will actually have access to this slides, and there'll also be a recording of this on our podcast and also on our YouTube. So you'll be able to review these as needed. In terms of getting ready, though, you need to decide who's going to be a responsible person for approving any changes to the risk assessment and the policies. You also need to appoint a compliance officer to do your checks to ensure they meet the requirements. As I said, these items 2 and 3, it can be the same person, which is often going to be the case, with small businesses, also operators. You need to be considering if you're part of a actual reporting group. And if you are part of a reporting group, then it must be decided which entity is going to be responsible for the AML or CTF obligations. So the senior manager is going to be responsible for overseeing and implementing the transaction. So if you are a small business, it's often going to be the director that does this. For the compliance officer, they're going to be responsible for the day-to-day process of ensuring the business is complying with their obligations. And for the requirements of a compliance officer, if that person, if they're employed at a management level, they must be a fit and proper person, and they must have sufficient authority, independence, and access to information and resources that they need. A reporting group as well can also include franchises, partnership agreements, or a wider corporate group. So we need to understand that the rules and regulations that you must comply with as the business owner. You know, there are a lot. Like I said, they're not going to stay the same. They will be changing and, you know, amended from time to time as the government, you know, sees things that are not working and needs to change them. Okay, step 7, we want to make sure that we're doing a risk assessment on our business activities and our customers base. You know, we ourselves want to challenge it. You know, if a client come to us today with, you know, like I said, purchasing a $15 million business, 20-year-old, we need to check, where did the money come from? You know, there's no, although it's not regulated and we're not required to start these things now, it's nothing stopping us from doing so. You need to consider where you need to develop the process to ensure compliance. So, you know, when we've done our own risk assessment, what were the deficiencies and how do we overcome that? You know, what is the solution? What compliance checks do we need to put in place? It's up to us to prepare the AML or CTF program. And if we are going to engage a third party, we need to do our due diligence in the service providers, as I mentioned earlier. It's fine to outsource things, but the obligation and responsibilities still fall on us as the business owners, you know, and major shareholders of that company. So you need to do your checks on this third party outsource company if that's the way you want to go about meeting obligations. So we need to still have a policy and procedure actually prepared, and we need to be ensured that we are enrolled by the deadline that they set out for us. So I know there's a lot of information. If you followed your current process basically on your last transaction, then would you be comfortable in defending it under these new AML laws? So most anti-money laundering issues in the property industry won't arise from deliberate wrongdoing. They'll arise because professionals like us didn't realize when the law actually required them to act. You know, when we were required to report to AUSTRAC and we didn't. You know, what is the penalty? We don't know at this stage, but you know, is our practicing certificate or our, you know, registered real estate license up for grabs? Or, you know, is it jail time? Is it a monetary penalty? So, you know, that there are going to be ramifications for not acting. So what we're doing at the moment, we're offering a post-webinar consultation to help you map out what your AML obligations are and look into what your actual role in the transactions are that you're doing so that you know exactly when to act and what you actually need to document. So if that is of something to interest to you, by all means, feel free to scan the QR code here on this slide and book in that consultation with us so that we can help map out your anti-money laundering obligations. You know, happy to have a conversation with you about this. Or if it's something, you know, slightly different, or I've not answered your questions in this webinar, yeah, feel free to book in that consult with that QR code. I will open it up now though. If you do have any specific questions, I may not be able to answer them all at this point in time, which is why I've given that link to the QR code. But hopefully, yeah, as we get more information given to us, we certainly will be able to answer them. But I'll see if we've got any questions at the moment. And what have we got here? None there yet. So yeah, I will. I'll put up a quick poll as well if we can get a bit of feedback from you about how you found today's session. If there's anything, you know, that we might need to include in a part 2 of this, you know, when we get more information from the government about how it's all going to work. So if you could still take the time to let us know how valuable this webinar was for you, we'd love to know. And while you're doing that, feel free to take yourself off mute, ask a question, or pop it in the chat box, and I'll try and answer that for you now. Thank you. All right, we've had a couple of responses on our poll. If you can just complete that, we'd really appreciate that. I haven't got any questions in the chat box yet, or no one's taken themselves off mute. But like I said, it is very new. It's probably very raw to a lot of people. I know it's a lot to take in. We are going to publish an article as well regarding this. Like I said, we're going to send out these slides. We'll be doing an in-person seminar as well on this in upcoming months. So if you're not subscribed to our mailing list, jump on our website and do so. And yeah, if there are any questions or topics you'd like us to cover in the future, please, by all means, drop them in the chat box, because we'd love to know. And hopefully our next month's webinar will be just that. So thank you everyone for joining us. Yeah, like I said, we'd love your feedback. So by all means, scan the QR code here. Give us a Google review. How we've presented today. We are up for feedback and making sure that these sessions are as valuable for you as possible. So yeah, happy to tailor them to suit your needs. Our contact details are there, and we'll try and reach out with you if you did want to arrange that consultation to go through your obligations under these new anti-money laundering laws a bit more. But otherwise, thank you everyone for your time. I appreciate that, and we'll keep you posted on the new laws as they come into play. Thank you.